Hello everyone, Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Aini binti Sulaiman and I am from DPM3S3. My registration number is 05DPM19F1111. And today me and my teammates, Thelma, Molla and Nur Aqidah binti Bolliana will present to you our EOC and we will be answering all the questions throughout this video presentation. Thank you!
Hello, my name is Thelma.
My name is Nur Aqidah binti Bolliana.
Alright, before we proceed to the first question in the EOC, I am going to read out loud the article of the EOC. So, on November 2018, Melvin, aged 28 years old, registered himself and Sandra, who is 16 years old, under the registration of Business Ordinance as trading in partnership, under the name of Melvin's Piano Academy. And at the same time, both of them wrote to Lala Bank in Kuala Lumpur applying to open a current account in their names and stating that they were partners of a firm and checks of the account would be signed by both of them, means both Sandra and Melvin needs to sign the check. And then they came to De La Salle Company to buy 2 units of piano for Melvin's Piano Academy. First question is to state one issue on agency based on the case given. So the issue is whether Sandra, who is a minor, can be registered under the registration of Business Ordinance as trading in partnership.
For the question 1.2, I will explain the most suitable type of agency with elaboration. The most suitable type of agency with elaboration is implied agency. Implied agency means an agency created from the conduct of the principal and agent. It is generally inferred by circumstances that imply an intention to create an agency relationship. As already informed, Melvin and Sandra have registered in the Business Ordinance as a trade in partnership with the name of the Melvin's Piano Academy. An implied agency is an actual agency and is a fact to be proved by deduction or inferences from other facts. As to third person, the principal is equally liable in the case of implied agency. In case of true implied agency, the third person needs to have knowledge of the principal's acts, nor should they rely on the same. Melvin and Sandra come to De La Salle Company, which is a third party, to buy 2 piano units for their business. At the same time, Melvin and Sandra wrote to Lala Bank in Kuala Lumpur to applying to open a current account in their names and stating they were partner of the firm and check of the account would be signed by both of them. The agent by implied authority being an actual agent, the principal is liable for his/her act the same as though the authority had been expressed. An implied agency must be based upon facts and facts for which the principal is responsible.
Alright, now we will be answering the third question of the first question, which is to state one conclusion based on the issue. So the conclusion for this issue is, even though Sandra is only 16 years old, which is not the age of majority, she has the legal capacity to register into a business ordinance as trading partnership with Melvin, who is an adult. However, Sandra is not liable towards any contractual liability in the firm. Moving on to the second question in the EOC and the first question for the second question, which is to explain the maxim caveat emptor principle with relevant provision. So maxim caveat emptor principle is a common law rule. It is also called as the rule of let the buyer beware. The relevant provision to this is Section 16, Sales of Goods Act 1957, or we also known as SOGA 1957. The buyer must exercise care when he makes purchase. If he does not, he must bear the consequences. So as a general rule, there is no implied warranty or condition as to the quality or fitness for any particular purpose of goods supplied under a contract of sale.
So as we know, caveat emptor is the integral part of Sale of Goods Act 1957, which is the Latin phrase that translates "let the buyer beware," and it means where the buyer themselves have the responsibility at the choice that they made. The job of the seller is to make the product to be available in the open market, while we as the buyer is to preview their items and make our choice accordingly. So if the products turns out to be defective, it is not going to be the seller's responsibility, it is our as the buyer responsibility because of the choice that we made. However, there are exceptions in this doctrine of caveat emptor. So let's take a look at the Melvin and Sandra's partnership case. So the first exception in Melvin and Sandra partnership is when the two pianos that they bought from Dalsol company met the expectation in goods of merchantable quality. So according to section 16 clause 1b of Sale of Goods Act 1957, where goods are brought from a description of a seller who deals in that goods of description, whether he is the producer or the manufacturer or not, there is an implied condition that the goods shall be of merchantable quality. Provided that if the buyer have examined the goods, there should now be implied condition as regards of defects, which such examined ought to have been revealed. Well, simply said, Dalsol company who is selling pianos according to description has a duty of providing goods of merchantable quality and is also capable to pass the market standard. So if the piano that Melvin and Sandra bought did not meet the merchantable quality, then it is not Melvin and Sandra's fault. Instead, it will be Dalsol's company's fault. However, if Melvin and Sandra had a reasonable chance to examine the piano, then this exception will not be applied. So the next exception that will be available in Melvin and Sandra's partnership is the usage of trade. So according to section 16 clause 2 of Sale of Goods Act 1957, an implied warranty or condition as to quality or fitness for a particular purpose may be annexed for the usage of trade. It basically means there will be an implied condition or warranty to the quality or the fitness of the goods or products. But if a seller deviates from this, then the rules of caveat emptor will cease to apply. Well, let's give this an example. Melvin and Sandra bought the two pianos from the Dalsol company just to find out later that the two pianos that they bought received in a really bad condition due to rocky road at the time of the delivery. So in this case, the rules of doctrine will not apply.
That is all from us and our answers for the EOC. Thank you.